appear for the respondents in this matter.
Sorry, Mr. Pillay.
Miss Pillay, my lord. Miss Pillay. Miss Pillay, my lord.
Okay. Sorry, and the other one is, so counsel for the applicant is?
Is Annelien van den Heever.
Heever.
Indeed, my lord.
Right, and Ms. Pillay, okay, yes.
So it's Mr. Durance together with Miss Pillay, my lord.
Well, yeah, okay, I was worried.
Yeah, I'm my learned junior is Miss Pillay, and I'm leading her, my lord.
Yes, okay.
The Lord thought Miss Pillay sounds very much like a colored man.
Of course. Ms. van den Heever?
My lord, we are ready to proceed. As I said, we're still waiting for the respondents' papers in this matter.
Well, I don't have them either. I suppose because it's urgent, maybe they want to make oral representations.
Well, my lord, yes, we were, as I pointed out last night, we were briefed last night. We prepared an answering affidavit which needs to be signed. We are opposing the application on the following basis. One, we say that just as a preliminary point, my lord, we say that the applicant is a peregrine of this country and going to ask for security for costs. Second, we're going to say the matter is not urgent because it's self-created. Thirdly, there's a defense. We have is defenses and there's no defamation. And fourthly, my lord, is that the relief sought in part A is incompetent. My lord, this matter is a matter of importance. It brings into play, into sharp focus, the right of the freedom of the media, freedom of speech, versus the right to dignity and privacy, etc., as alleged by the applicant, my lord. So we have a difficulty, my lord, in the sense that of having the affidavit signed and commissioned because Mr. Dlamini, who's the second respondent, is currently being sought by the security forces in this country in this country by the Swazi government, my lord, and it's difficult for him just to make normal arrangements and come and sign the affidavit. They need to have a security assessment, etc., my lord. This is not the first such application, my lord. The acting Prime Minister of Swaziland, on behalf of the King and the royal family and the ministers, has brought a similar application in this court, which is pending, my lord. And in that application, my lord, the same allegations in respect of his safety is made, my lord. So it's not something far-fetched. It's not something that I'm pulling out of nowhere, my lord. It's a matter of public record, and he's going to say it again in this application, my lord. So, my lord, what I suggest is the following, and I've asked around, my lord, and I consider, I don't know the practice of law court, my lord, but I've asked around from colleagues, my lord. They say, and this is a suggestion I'm making to your lordship. Apparently, there's a form B that we have to fill in. The appropriate way to deal with this matter is to have it case managed and have a form B in where we can agree on the filing of time frames of filing of paper. So if we lodged an application for the notice for security for costs and there's non-compliance with that notice, my lord, then we obviously have to bring an application to compel them, whether we don't know whether we're opposed or not. But in my view, that will first have to be disposed before we deal with the main application, my lord. We are ready to proceed this week, my lord. But given the practical difficulties and defenses being raised, I'm not sure whether your lordship is prepared to entertain the matter in a peaceful fashion.
I'm not sure. Form B, where does that come into this?
I'm not sure, my lord. They said, my advice from my colleagues, our senior colleagues in the Pretoria bar, is that there's a practice in this court that in your lordship's division, I'm not sure, my lord.
Yeah, no, that's right. All matters are case managed, but yes. This is an urgent matter.
Yes, my lord.
So normally you don't case manage, unless, of course, we stand it down. And, well, as an urgent matter, I don't think that will be applicable here. But normally it applies in motion court and even in trials where you let the parties choose, they create their own rules, so to say, okay, by this date we will do that and that and that and that. And that's what it entails. So here, I'm not sure, unless you say, lack of urgency is considered, and I'll refer, if Ms. van den Heever were to say that, I'll then refer this matter to some other role where it would be case managed. But that's not the case here.
No, that's not the case. We won't concede that the matter is not urgent. We submit, along with the case law in this regard, that the matter is urgent indeed.
And I'm saying that's why I'm just outlining it to him to say that doesn't apply here unless you were to say the matter is not urgent. Yes. So since you're challenging urgency,
Lord, may I make the suggestion? We have our answering affidavit ready. It just needs to be signed. We've just been waiting for this appearance before your lordship for us to consult. I didn't want to have a consultation while waiting for your lordship. May we be granted leave to file our answering affidavit where we can deal with all these issues. So an answering affidavit, say before the close of business today, the applicant can reply whenever they need to reply. My lord, we prepared to be in court, even on Thursday or Friday, my lord, and have the matter argued properly, proper heads of argument, everything, all the papers should be ready before court. So we're prepared to do that, my lord.
Okay, let's hear from Ms. van der Heever.
My lord, in principle, I've not taken instruction, but in principle, I've got no issue with the suggestion. It is, however, the issue of today's wasted costs that needs to be dealt with. And I, in that regard, would suggest that my learned friends, the respondents tender the wasted costs for today, that we then stand the matter down as suggested, and that we set timelines in regarding the filing of the affidavit and then the hearing of the matter. But it must still be this week, and this we do without any concession pertaining to urgency.
Yeah.
In other words, we do not wish to this to be dealt with later by my learned friend as that the matter has lost its urgency by us agreeing to stand the matter down.
Yes.
My lord, the matter stands on, I beg your pardon, until the end of the week. As I understand the practice of courts is that if you briefed for the week, you briefed for the week in the urgent court. In any event, the court, this matter will come before you again this week, my lord, and then only will you be in a proper position to determine costs. So costs in respect of today should be reserved and determined at the hearing of this application later this week, my lord.
No, but you see, I think I will differ with you, because when did you receive notification of this application?
Lord, it was emailed, my lord. It was emailed to the second and third respondents on the 17th, my lord. Paragraph 14. The allegation is made the following.
So 17th of what?
Sorry, 7th of January, my lord. 8th of January it was issued. So 8th of December, beg your pardon. 8th of December, the application was issued, my lord. And then on Wednesday last week.
That was the 8th.
Yeah, it was emailed to the first and second respondents, who only obtained access to it late in the week, my lord. So in any day, my lord, it's 5 or 6 days notice before today. It's not sufficient. I don't think, my lord, if one has regard to 6 days, the application is brought on the issue on the 8th to be in court in 6 days, my lord. And given the current situation in which the second respondent finds itself in regard to his fears for his safety, my lord, we submit, my lord, that in any event there would have not been sufficient time. You email a document on Wednesday for this time of the year, my lord, and try and get something in, my lord, and we also respectful submission that is extremely unreasonable, my lord. And we submit, my lord, the issue of costs can be determined when the entire application is heard, my lord, and your lordship will be in a position to determine the cost, then in a globular position, in a globular way, my lord, on a holistic way. We submit that the application is still on since inception, and it would the manner in which to deal with this matter, the cost in this matter is to have it determined when your lordship deals with all the facts, my lord. Those are my submissions.
Lord, with the greatest respect to my learned friend, he is correct when he says the application was mailed on the 8th. We have strictly followed the practice rules in this honourable division, pertaining to the filing of papers and service when it comes to an urgent matter. The applicant served, as I say, by way of email. I'm glad my learned friend conceded that. The fact is that the respondents seem to have easy access to their emails. In fact, on Sunday, there was a publication on the website of the respondents pertaining to this matter. I respectfully submit that in line with the practice directive of this Honourable Division, that the time was sufficient.
But for what? For
filing its affidavit, my lord. For the respondent filing their affidavit and the notice to oppose.
Were you notified of their notice of intention to oppose, or their notice of intention to oppose?
My lord, notice was filed yesterday, but already, as I've indicated to your lordship, if your lordship has regard to our bundle of documents, 53, page 53A to C, Friday, before we even the respondents opposed the application, they already reported on the application on the website. And it's already been conceded that they received the papers on the 8th, last week on Wednesday.
Yeah. Any other thing?
I've got nothing further, my lord.
Thank you. Now, do I extend it down to Thursday or Friday?
We in your lordship's hands. I would submit in that regard. I would hate to be the one to ask your lordship to work on Thursday.
Well, my week is ruined already.
I'm quite willing to do that, my lord, but as since it is a public holiday, we definitely in your lordship's hands in that regard.
Yes. Shall I ask the respondent?
My lord, Thursday or Friday is fine with me, my lord. Thursday is actually better for us, my lord. At my age and all the commitments I have, I'd rather be finished before Friday than Thursday. Thursday be fine to do, my lord. They can file the reply tomorrow, and then we can be in court on Thursday with heads of argument.
Fine. Let's try to hear it. Thursday?
My lord, I have no objection to the matter being heard on Thursday if your lordship is so inclined.
Oh, yes. But by the way, okay, let me just make this order first. This matter stands down to Thursday at 10 o'clock, and the respondent to pay the wasted costs of today.
Yes, please, lordship.
And applicant, you're required to send a link for Thursday, please.
We will do so, my lord. Does your lordship prefer Zoom or Teams?
Doesn't matter, either.
We'll do so, my lord.
Thank you.
Yes, please, my lord.
Council is excused.
Thank you, my lord. Have a good day, everybody.
You too.
Okay, that's the end of the judge.
Thank you for the judge.